Title 13, Crimes Against Honor. Chapter 1, Libel. Section 1, Definitions, Forms, and Punishment of this crime. Article 353, Definition of libel. A libel is public and malicious imputation of a crime or of a vice or defect, real or imaginary, or any act, omission, condition, status, or circumstance tending to cause the dishonor, discredit, or contempt of a natural or juridical person or to blacken the memory of one who is dead. Article 354, Requirement for publicity. Every defamatory imputation is presumed to be malicious even if it be true, if no good intention and justifiable motive for making it is shown, except in the following cases. 1. A private communication made by any person to another in the performance of any legal, moral, or social duty. And 2. A fair and true report made in good faith, without any comments or remarks of any judicial, legislative, or other official proceedings which are not of confidential nature, or of any statement, report, or speech delivered in said proceedings, or of any other act performed by public officers in the exercise of their functions. Article 355. Libel means by writings or similar means. A libel committed by means of writing, printing, lithography, engraving, radio, phonograph, painting, theatrical exhibition, cinematographic exhibition, or any similar means shall be punished by prisión correccional in its minimum and medium periods, or a fine ranging from 200 to 6,000 pesos or both, in addition to the civil action which may be brought by the offended party. Article 356. Threatening to publish an offer to present such publication for compensation. The penalty of arresto mayor, or a fine from 200 to 2,000 pesos or both, shall be imposed upon any person who threatens another to publish a libel concerning him or the parents, spouse, child, or other members of the family of the latter, or upon anyone who shall offer to prevent the publication of such libel for compensation or money consideration. Article 357. Prohibited publication of acts referred to in the course of official proceedings. The penalty of arresto mayor, or a fine of from 20 to 2,000 pesos or both, shall be imposed upon any reporter, editor, or manager of a newspaper, daily or magazine who shall publish facts connected with the private life of another and offensive to the honor, virtue, and reputation of said person, even though said publication be made in connection with or under the pretext that it is necessary in the narration of any judicial or administrative proceedings wherein such facts have been mentioned. Article 358. Slander. Oral defamation shall be punished by arresto mayor in its maximum period to prisión correccional in its minimum period if it is of a serious and insulting nature. Otherwise, the penalty shall be arresto menor, or a fine not exceeding 200 pesos. Article 359. Slander by deed. The penalty of arresto mayor in its maximum period to prisión correccional in its minimum period, or a fine ranging from 200 to 1,000 pesos shall be imposed upon any person who shall perform any act not included and punished in this title, which shall cast dishonor, discredit, or contempt upon another person. If said act is not of a serious nature, the penalty shall be arresto menor, or a fine not exceeding 200 pesos. Section 2. General Provisions. Article 360. Persons responsible. Any person who shall publish, exhibit, or cause the publication or exhibition of any defamation in writing or by similar means shall be responsible for the same. the author or editor of a book or pamphlet, or the editor or business manager of a daily newspaper, magazine, or serial publication shall be responsible for the defamations contained therein to the same extent as if he were the author thereof. The criminal and civil action for damages in cases of written defamations as provided for in this chapter shall be filed simultaneously or separately with the court of first instance of the province or city where the libelous article is printed and first published, or where any of the offended parties actually resides at the time of the commission of the offense, provided, however, that where one of the offended parties is a public officer whose office is in the city of Manila at the time of the commission of the offense, the action shall be filed in the court of first instance of the city of Manila or of the city or province where the libelous article is printed and first published. And in case such public officer does not hold office in the city of Manila, the action shall be filed in the court of first instance of the province or city where he held office at the time of the commission of the offense, or where the libelous article is printed and first published. And in case one of the offended parties is a private individual, the action shall be filed in the court of first instance of the province or city where he actually resides at the time of the commission of the offense, or where the libelous matter is printed and first published, provided, further, that the civil action shall be filed in the same court where the criminal action is filed and vice versa, provided, furthermore, that the court where the criminal action or civil action for damages is first filed shall acquire jurisdiction to the exclusion of other courts, and provided, finally, that this amendment shall not apply to cases of written defamations, the civil and or criminal actions which have been filed in court at the time of the effectivity of this law. Preliminary investigation of criminal action for written defamations, as provided for in the chapter, shall be conducted by the provincial or city fiscal of the province or city, or by the municipal court of the city or capital of the province, where such action may be instituted in accordance with the provisions of this article. No criminal action for defamation which consists in the imputation of a crime which cannot be prosecuted de officio, shall be brought except at the instance of and upon complaint expressly filed by the offended party, as amended by RA 1289, approved June 15, 1955, RA 4363, approved June 19, 1965. Article 361. Proof of the truth. In every criminal prosecution for libel, the truth may be given in evidence to the court, and if it appears that the matter charged as libelous is true, and moreover that it was published with good motives and for justifiable ends, the defendants shall be acquitted. Proof of the truth of an imputation of an act or omission not constituting a crime shall not be admitted, unless the imputation shall have been made against government employees with respect to facts related to the discharge of their official duties. In such cases, if the defendant proves the truth of the imputation made by him, he shall be acquitted. Article 362. Libelous remarks. Libelous remarks are comments connected with the matter privilege under the provisions of Article 354, if made with malice, shall not exempt the author thereof, nor the editor or managing editor of a newspaper from criminal liability. Chapter 2. Incriminatory Machinations. Article 363. Incriminating innocent person. Any person who, by any act not constituting perjury, shall directly incriminate or impute to an innocent person the commission of a crime shall be punished by arresto menor. Article 364. Intriguing against honor. The penalty of arresto menor or fine not exceeding 200 pesos shall be imposed for any intrigue which has for its principal purpose to blemish the honor or reputation of a person. We hope you have enjoyed listening. More audiobooks are coming your way. Please support by clicking the subscribe button and bell icon to receive notifications of our latest upload. A like and share is appreciated. Audio and performance copyright by RAK Audio